A warm welcome to you, our viewers, on the Link edition for this week. And we always keep our promise to give you information that you can use and opportunities. And tonight we're discussing a very important issue that concerns the Succession Law or Succession Act of 2022. It has to do with how people and families can go about this succession issue in the case of death of an important person in the family. But many people have trouble because they don't know things that they should know. And on the Link, many times we bring you things that you ought to know, but you don't know. And we facilitate your knowledge because there's an advantage in knowing. Tonight, succession law is our topic. And I have the right person in the studio to furnish us with information around this subject. We have Miss Patricia Kamgisha, Associate Partner at Kampala Associated Advocates. Patricia, welcome.
Thank you.
All right. 2025 is a very important year for the succession law, which was amended in 2022. Can you take us through why should I mind about 2025 in as far as this succession law is concerned?
Thank you. Now, the reason why 2025 is a significant year in our succession law is because of the term limit that was introduced in the amendment of 2022 on the validity of letters of administration and probate granted to persons managing estates of deceased persons. Now, with the amendment, the time limit on letters of administration that were issued prior to May 22 is a 3-year period. So a person who has gotten letters of administration is supposed to wind up the management of the estate and distribution within a period of 3 years. Now remember, the amendment was made in 2022, so the 3 years lapsed in May 2025, which is why we saw a stampede of sorts with many people trying to have extension of these letters or worried about, okay, what is the impact of this term limit? My letters have expired, what do I do? And then also need to take note that letters that were issued after May 2022 were given a period of 2 years. So again, any letters of administration, any grant of probate that was granted before May 2022 lapsed in 2024. All hope, though, was not lost. The law made provision for extension of these letters of administration, so people should be aware that they can apply to have the letters of administration extended, which is something lawyers are assisting with. So I would advise anyone who is in that kind of situation to approach a law firm to assist them in getting the letters of administration or probate extended. Just one small thing. Somebody may be wondering, we are sort of teaching people letters of probate. Well, help me understand what that means. Now, what probate is, it arises when someone has died and left a will. So they have left a testamentary disposition of how exactly they would want their estate managed. So in that case, you apply for probate. However, where someone has died without making a will, they have died intestate. In that case, what is applied for is letters of administration.
So probate is where there's a will. Administration is where there is no will. So even when somebody has left a will, we still need to apply to administer the will, correct? That's very important. Let's move to the next question. What are the key facets of the Succession Act outside of the first question we asked? Especially in the case where you call it intestate, where somebody has died without a will. What are some of the things I need to know about this law so that I do the right thing?
Thank you. Now, where someone has died without a will, the law has brought in certain amendments to ensure protection of spouses, of the children of the deceased that have been left behind, of the dependent relatives. So what the law has majorly introduced is protection of the main residential holding of the deceased person. Now, that is reserved for the spouse. Main
residential holding is basically a family house sometimes, matrimonial home.
Where you've been residing prior to the death of the person. So that is reserved for the spouse and their lineal dependents.
So spouse here would mean even a man?
Yes.
Sometimes people think spouse is lady.
No, now that was revised. In the previous regime of the law, there was that sort of bias.
Yes.
The law was catering more for the men, but with the amendment, they have introduced equality. So the law has done away with things that relate only to a male. They provided for spouses rather than husband or wife to cater for all genders.
So it's the home is for the wife or husband who was left behind and the children.
Yes.
Please go on.
Yes. So in addition to that, what the law has introduced is the requirement for taking out 20% of the estate of the person who has died intestate, specifically to cater for maintenance of any minors that they have left behind or any dependents that they have left behind who are wholly dependent on them, or disabled persons who they were taking care of and they were wholly dependent on them. So again, even when someone dies intestate, the law has made sure that protection has been given to those ones who might be affected by someone passing on and they haven't made any decision
they're
on how
not
they're
adults.
Yes.
They're still in school.
They're still in school. The law has tried to provide protection for them.
Okay.
Then also another thing the law introduced, especially in relation to intestate cases, is a revision in the percentage that is to be given to spouses.
Okay,
now,
that's very interesting.
Previously, there was a minimal percentage that was going to them, and there was that concern of what if there are very many wives or wives usually.
Yeah, wives usually.
Yes. If there are very many, what happens when they have to only share this small percentage?
Yeah.
So the law has increased that.
Okay.
Yes.
Where are we at now?
We are 20%.
So if a man, in this case, for example, gender sensitive, dies, the chunk of their estate, 20% of it, is reserved for the wife or wives that's left behind.
Yes.
Okay, very clear. Please take us through more issues on the law. I need to know.
Okay.
Yeah.
Now again, relating to intestate succession.
Yes.
What basically people would have to know again is that they need to apply to the Administrator General for no objection, for them to be allowed to go ahead and manage this estate. The law gives preference to a spouse to apply for these letters of administration because really they are the person who have been closely in relation to the deceased. So they take first priority. However, in the event that someone else would be more entitled to those letters of administration, or there's an issue with the wife or the spouse that has been left behind.
They had left in the meantime, the man died or whatever, they were not there, but they were still married.
Yes.
Issues like that.
Issues like that. Still, court can guide on how the administration can be done.
Okay. Can there be, in your experience, where is the contentious areas between the wife? I'm assuming the wife here has the, for example, the main, the law allows them to be the one to apply for letters of administration, especially. And what are the areas of contestation normally with the family? Because that should be automatic, but it's not always. What's your experience like?
Now, in some cases, you may find that maybe they have been separated. Yeah. So in that instance, what happens? Of course, the wife might try to apply, but court will have to consider the circumstances under which the separation happened. If a spouse separated because they were away on study for a certain period, then that is not going to be taken really as separation. Then again, if the separation was caused maybe by the person who is deceased, then again, it's not going to be taken to be a fault of the spouse who is surviving. So the law will take all that into consideration and listen to both parties and guide on how it should be done.
So it's only given when there are no question marks?
Yes.
Or even if they are raised?
No question marks. The beneficiaries have given their consent to the letters of administration being granted to the surviving spouse, and they know that it's going to be done in the best interest, really, of the family. I
also see that their children are involved. If there is a mother and the children and they are above 18, all of them are entitled. How do they resolve that?
But the mother would take precedence over these children. Yes.
All right, we are going for a short break now. We are coming back to see, I mean, these are the issues that cause headache. Somebody has died and the family can't agree. Sort of they are fighting, but the law, tonight Patricia is telling us the law that is helping us to resolve these issues. We'll come back after the break. Don't go away. Welcome back from that short break. We are continuing with very important issues that have to do with the succession law, the law that guides issues of succession, property, etc., in case somebody who is the owner of an estate or property has died. And we have been especially focusing in the first part of this show today on the case where the will has not been left. Normally it can be fairly easy when the will has been left behind. Yes, there can be issues, but less issues. But when the will has not been left behind, then they can be the best. But the law has set certain clarities, if you like, in as far as the rights of the spouse, of the children, and of the clan are concerned. And the person taking us through this, she deals with it every day, is Counsel Associate Partner Patricia with Kampala Associated Advocates. She was there on part one, and we come back to you, Patricia. Is there anything else we have left out in the key facets of the Succession Act that you'd like to talk about?
In relation to intestate succession?
Yes, no will.
Okay. Aside from the fact that the residential property has been kept, maintenance is provided for, the law provides for protection of the minors. In the event that any have been left, they have that entitlement to some money being kept for them to be taken through school and they complete. Then also, we also need to take into account the fact that the law has protected the spouse, really. Even if someone remarries before the estate has been distributed, the law allows for them to have their entitlement to the estate.
Say that again slowly.
Even after a spouse has remarried.
That means, and let's use the common example, Patricia, the husband has died, but the wife goes on to remarry elsewhere.
Remarry before the estate has been distributed. That does not disentitle her to her share in the estate.
Thank you for bringing that point, because that's one of the common areas of problems. That she got married. What does she want with all her other things?
No. Her share, she has to get.
I like that point, ladies especially. But even gentlemen, take note. You still have your rights to the estate of your former partner, even if you have remarried. That one I'll remember. Particularly.
Remarry before the estate.
Before the estate, yes.
So you are still married by the time they died, and then yes, you remarry before.
Patricia, I also know, help us on this issue. The law also is called intermeddling. It puts punitive measures on administrators. Please tell us about that.
Yes. So the administrators have a duty to administer the estate, to distribute the assets of the deceased and make sure that they act in accordance with the law. The law has already set certain percentages that they have to give to each spouse, the lineal descendants, the dependents. So where an administrator is not adhering to the law has come in and put specific penalties now. Previously, it was just saying this is an offense and not exactly specifying how much. But now, you will be charged a fine, or you could be taken to prison. Yes. And then people who just come in and start distributing or taking over property without having letters of administration, because maybe they feel they have an entitlement, those are also penalized by the law for intermeddling in the estate. It
does seem then what we said earlier, and let's come back to that point for the sake of the viewers, maybe they missed the first part. There is a time limit to my being an administrator, correct?
Yes, there is. So if you got your letters of administration prior to May 2022, you have a 3-year period which has already lapsed. So you're supposed to apply for extension of the letters of administration or probate that you have. If you get these letters of administration after May 2022 and going forward, you only have 2 years to administer that estate. So you have 2 years to do your business, distribute the assets, make sure you put whatever has to be put in trust for any minors, and then get out of that estate.
Okay.
Yes.
What does the law give me rights as an administrator, or for me, I just do things and go away? Any entitlements or what? What if there are appointments as an administrator, what are my expectations? Does the law say anything about that?
No, not necessarily. Now, an administrator could be a family member.
Yes.
Yeah. So you as a family member are entitled to a certain portion of the estate. So you would only get that share that you're entitled. It's not that you're supposed to get any particular payment.
Okay.
Yes.
Finally, as we wind up, there is something I saw: estate distribution and guardianship. There is 20, 75, 4 and 1%.
Yes.
Distribution. It's very important to tell us about that. I know you touched the 20%, but then you never told us about the other percentages.
Okay. Yes, so 20 is for the spouse, 75 is for the lineal descendants. Okay. The 4% is for dependents. Now, those are people who are wholly dependent on the deceased, not just a little dependent. So the person has to have been taking care of you, and so you are getting your survival from them, really. You get 4%. Now, 1% is for the heir. That's the person who has been chosen as a successor of the deceased. Yes, that's where the percentages come in.
So say that again, 1% is for the heir.
The heir.
What they call the customary heir.
Yes.
Yes. There's this term
who could be a female or male.
Of course.
Doesn't matter. Yes.
I like you emphasizing that.
Yes.
Now there's an issue. Let's go back a bit. Lineal descendants get 75%. Do we assume those are just children?
Yes, the lineal descendants are people who are coming from the lineage of the deceased person. So those would be his children directly, or maybe his sisters, brothers, people coming from his line.
Okay, children, relatives, but he must have... remember,
relatives, though, will fall more under the dependent. Because if they were surviving on him, like his sisters, will fall under that.
Viewers, you see this division 20, as Patricia has told us, 20% for the spouse and 75% lineal descendants and so on, 4% to the dependent relatives. That can also cause issues. And therefore the advice would be to take away all this headache where the lawyers and the judges have, and the family have to contest over who belongs to this apart from the spouse. Perhaps it's important to do a will, correct, Patricia?
Yes, it is.
Which is more preferable? Definitely, do a will.
Definitely do a will. And then you also have to remember that in doing your will, you have to make sure that it is in compliance with the law. Okay. So it has to be signed properly. It has to be executed by the testator, sign on every page, write the name, write the address. A testator is the maker of the will? The testator, yes. Sign on every page, write your name, write your address. And then also have it witnessed by at least 2 people. They don't necessarily have to be in the room together, but they have to. You have to see them and talk to them and explain, and then they can witness.
I'm told if I die and I've done a will, the will has to be registered again.
Not necessarily registered, no. You can have it kept with maybe your lawyers, and have a copy given to the witnesses, so that at the point of your death, they have like 3 copies come out and they are all the same. So that's easier to confirm that yes, this is actually
there is no other step I need to do to say this is the will apart from witnesses and all that? Witnesses,
signing it properly, leaving a copy. You could leave a copy with the Administrator General just to be safe. But then upon your death is when there's need for the people that you have left to execute it, to present it to the Administrator General, to have him prove that yes, this is valid, and then they go ahead to court and get a grant of probate. Okay. Thank you very much, our guest tonight, Miss
Patricia Kamgisha, Associate Partner, Kampala Associate Advocates. Viewers, we took it slow. This is law, but it touches where it hurts and where it's complicated, property and death. But we need to know, because eventually, those eventualities are inevitable. We hope we added value to you tonight. Thank you for joining us. That was The Link.